Weekly today, legal practitioners identify some challenges still facing the legal system, even as courts across the country conclude new legal year ceremonies. And reactions continue to trail the crisis rocking Ekiti State and the attempts to undermine the state's judiciary.
Even unlettered Nigerians seem to know the dastardly implication of the desecration of the hallowed temple of justice, which certainly is one of the strongest pillars of the political system of democracy and of modern civilization itself.
The Attorney General and Commissioner for Justice in Lagos sheds more light on the 75-year jail sentence passed on 3 Boko Haram members.
We made an app for the proceedings to be in camera, that is, to be heard in secret, as it were, to the exclusion of the press and members of the public. This was purely for security purposes.
That's the lineup for this episode of Law Weekly on Channels Television. I am Shola Sheyeli. Welcome. One of the big news of last week was the conviction of 3 Boko Haram members. The Federal High Court sitting in Lagos last week Tuesday sentenced the men to a 75-year jail term with hard labor. The trial was conducted in camera, and the judgment was also delivered in secret by Justice Ibrahim Buba, following an application on the need to protect witnesses in the case. Some people have expressed reservations about the judgment, wondering why the convicts were not sentenced to death. The Attorney General and Commissioner for Justice in Lagos, Mr. Adepaye, who prosecuted the case, explains the rationale for the jail terms.
It's a matter of judicial discretion, but I can give you some explanations. There are 3 possible levels of criminality, if I can put it that way, just for convenience. A criminal could have committed the act, and that's the ultimate. For instance, a terrorist has detonated bombs and people have been killed. That is the ultimate, isn't it? Then he could have attempted to bomb a particular location. That is, he would have installed the bombs. Maybe they failed to go off, or before they go off, the law enforcement authorities are aware. That is the second level of attempting. Okay. The third level is preparing to commit the act. Okay. Preparing acts preparatory to committing an act of terrorism. That is, you have bought the bomb-making materials, you are assembling them in your house, you are yet to take them out to any public place, you are yet to deploy them, you are yet to make the attempt. Okay, but you are making, you are doing things preparatory to attempting. So the time at which these suspects, or now convicts, were apprehended was at the 3rd stage, where they were still making preparations. They had not, we couldn't charge them for attempted, for instance, because they had not attempted. The explosives were found in their own homes, okay, where they were keeping them and making preparations. So, do we need to strengthen the law? Let me tell you, this law already prescribes a death penalty for this same offense, maximum death penalty. Okay, but what a judge will look at, and maybe I'm speculating now, but a judge will be right to look at the fact of whether the explosives had been used, whether they had caused injury or death, in determining what penalty to impose. Also, it was not part of this case. We didn't have evidence to say that these same 3 persons were the kingpins or they had been involved in other incidents of terrorism which had led to death elsewhere. If they had, we would have charged them for something higher, for murder, in fact, in addition, even if they were not the people directly detonating bombs, if we had shown the connection. But it appears that they were recruited for the Lagos operation. They were people that were living in Lagos here. And so that is the context in which I think the court decided to impose no more than 25 years. Now, you are right that sometimes if you have 5 counts, as we do in this case, and the court awards 10 years for some, 5 for some, 20 for some, if all of them are to run concurrently, it is the maximum of 20 that will subsume all the other terms of imprisonment. But in this case, the court decided that under the Terrorism Act, all of the convictions will run concurrently, and that has a maximum of 20 years. Now, they also committed offenses under the Firearms Act, and he thought when you finish serving your terrorism sentence, then possession of firearms and all the other charges, you come to that. And that is why the court ordered that it should be 20 plus 5.
Another issue that has hogged the headlines is the crisis in Ekiti State, southwest Nigeria. On the 23rd of September, there was the unpleasant news of thugs invading the Ado-Ekiti High Court and the assault of judges and judicial staff. Since that incident, there has been no shortfall of reactions, with many calling for the protection, integrity, and sanctity of the judiciary, especially from politicians. The latest reaction is coming from the Ikeja branch of the Nigerian Bar Association, popularly called the Tiger Branch. The branch says that it sent a fact-finding panel to the state and interviewed key persons. Part of its findings was that the governor-elect, Mr. Ayofayoshe, did not join in the assault of Justice Adeyeye, but neither did he do anything to stop it. The branch made certain recommendations.
In view of the fact that our democracy was hard-won from long years of jackboot rule of the military, it should be the concern of all well-meaning Nigerians, particularly legal practitioners, to protect same zealously. We construe the attacks on the Ekiti State judiciary a serious threat to the existence of democracy in Nigeria. This is because the attacks were clearly carried out with the aim to stop the court from discharging its lawful and constitutional responsibility of adjudicating over disputes brought before it. Evidence abounds that the invaders of the court had clear intention to run the courts and the judiciary. Their action in proper legal context was well near treasonable. Sorry. A democratic society where the judiciary is intimidated from deciding matters, especially political ones, must sooner than later break down and dissolve into anarchy, where might becomes right. This will be an in-win that will blow no one any good. We call on all Nigerians to rise up above sectarianism and partisan politics, to condemn and to act against intimidation and humiliation of the judiciary, lest those shameful, barbaric, and retrogressive incidents set a precedent and become a contagion. We condemn the delayed reaction of the police in the crisis at hand. While the police circumspection and concern to avoid bloodshed and possible loss of life in the discharge of their duty is highly appreciated and commendable, overcautiousness and aloofness by the police in the face of the perpetration of criminal acts, including the desecration of the judiciary, is nothing but gross, even criminal dereliction of duty, and lays the police to a reasonable charge of bias and unprofessionalism. In the event, the NBA Ikeja branch respectfully present the following recommendations. In view of the situation of substantial peace and normalcy at the Ado-Ekiti, contrary to press hype of insecurity and militarization of the town, the closure of the court should be lifted immediately. The Ekiti State Police Command should be more alive to its constitutional responsibility of protecting lives and property. Specifically, they should create a security atmosphere conducive to unhindered administration of justice.
The National Judicial Council, NJC, after an emergency meeting last week, also condemned the attacks on the judiciary. The council wants the Inspector of Police, Mr. Suleiman Abba, to take over and investigate the alleged attacks on 2 judges and the members of staff of the Ekiti court, with a view to bringing the culprits to justice. The NJC also asked the police boss to, as a matter of urgency, provide adequate security to judicial officers in the state, even as it gave the assurance that all petitions forwarded to it by all parties are being looked into.